I understand arguments and bases for D. I understand and appreciate your arguments for F. G, however, G is acted under extreme duress or under the domination of another person. And I'm just going to phrase it as walking around knowledge of that statutory basis is it's generally a confederate or a co-conspirator or a principal to the offense, as opposed to that basis being used for the victim. The victim is the one that was causing the duress. That's where I think F comes in. The victim's the initiator, the aggressor. So do you have any case law or any law for me that G can also apply, the duress portion can be applied from the victim in the matter as opposed to a confederate, co-conspirator, or principal?
Yes, I don't have a case at hand for the court, but the distinction I will make for the court is let's not be too narrow and interpret that only as it relates to the incident itself. The point I tried to make through the testimony of Dr. Russell was that Ms. Benefield's state of mind on that day, given the prior history of domestic abuse, when in the company of Douglas Benefield, already created in her, because of this past trauma, extreme duress. And I understand the court's distinction, but I do not believe that there is any case law that says that the duress is limited to the moment of the act. I believe the duress can be present from prior occasions, and that was the point I wanted to establish for Your Honor.
All right. Final question. You had mentioned about and this was both in your memo and in your statements today, Dr. Broder's testimony where, I don't know what the best word is, I'll say walked back his testimony from the stand your ground hearing.
Yes, sir.
I'll just characterize it that way.
Fine.
And you talk about, so we had the stand your ground hearing. It was my understanding from the reading, because he wasn't impeached with any deposition testimony at the stand your ground hearing. The deposition you're talking about happened after the stand your ground hearing.
Correct.
Okay. All right. That was all my questions. Did you have any further statements you want to make in response to the questions I've asked?
No, other than even though the deposition of Dr. Broder occurred after the testimony, it doesn't lessen what we perceive was the court's linchpin for the stand your ground order, which was tied to, at best, a mistaken statement, and at worst, a false statement to mislead the court.
I understand. Thank you. All right, State.
Judge, I'm not going to address the alleged errors and things that happened during the trial. I believe that's not appropriate for the sentencing. While I do disagree heavily with most of what he said about those issues, I'm not going to address them independently. I do want to address some of the things that the defense said about what knowledge we have of the situation. So the defense kept saying the word independent evidence over and over and over, and that the court should look to the independent evidence of Douglas Benefield's behavior to support some of these downward departure reasons. However, I have arguments about some of those things that the defense said. For instance, the defense wants you to look at Doug Benefield's deposition testimony that was not allowed to come in to the trial. And we all know that there were reasons that was not allowed to come in the trial. It was following the rules of evidence. However, I can represent to the court that at least one of the things that Mr. Taylor said is completely inaccurate, that Doug Benefield, while he admitted to firing the gun, he never said he did it to intimidate her. So I would just ask that we be cautious about what we are presenting as fact when it is not necessarily fact. The defense also said that Doug Benefield violated the South Carolina injunction. That is also one thing that was never established definitively one way or another, whether he violated it. The defense said that Doug Benefield was caught by a neighbor spying into the house. There are differences of opinions as to that, and I think we went through that in trial, that it was just supposition and someone being identified by a voice after the defendant played a voice recording for her. So that's in dispute, whether he was actually there or not. So to take all of these things as factual and allow them to be used in such a way to say that he was a willing participant in this set of behaviors, I would argue is inaccurate. The defense also said that Dr. Quintal said that Doug Benefield was super controlling and an alpha male, but if the court recalls from trial in cross-examination, I asked him, is this opinion based on, at least in part, based on what Ashley Benefield is telling you? And he said yes. So it wasn't that it was his own independent evaluation of Doug Benefield. He was taking what this defendant was saying to him and incorporating that into his opinion. The defense also said that Dr. Ferris said that Doug was a classic abuser. The court, in the state's opinion, correctly ruled that that was inappropriate opinion testimony and was not allowed in front of the jury. And again, there are all kinds of reasons why that's not appropriate evidence to be considered by the jury. And I would say it's inappropriate for the court to consider that as fact in a sentencing. So what we do end up having is bits and pieces of a rocky marriage that in the state's argument do not rise to prior acts of domestic violence. Doug Benefield had problems. He lost his temper sometimes. So did the defendant. They had arguments. It was a marriage, and that happens in marriage. The victim, was never an abusive husband the way the defense keeps trying to represent. That is a fictitious idea that Ashley Benefield has put forth and guided through this entire process. And Dr. Russell even said today and acknowledged that she knew that Ashley Benefield had been diagnosed with histrionic personality disorder, and that one of the symptoms of histrionic personality disorder is that you tend to exaggerate and blow things out of proportion. And that is the state's entire theory, is that this particular defendant just blows things out of proportion and makes things into something that never existed. So the court should consider that in trying to determine whether this victim somehow played into this whole incident that happened the night of the shooting. One of the other things that I will mention from what the defense was alleging was improper rulings by the court, I do want to say in isolation just this one thing. The DNA report, the defense was saying that it would have shown that Doug Benefield's DNA was on Ashley Benefield's arm, and I believe that's a false statement. It would have shown that there was some DNA on her that could have been Doug Benefield's DNA, but it also could have been a family member. And the child, that was a toddler at the time, was clearly a family member. So to imply that the DNA report would have clearly shown that Doug Benefield was holding her and at the time that this incident was going on, I believe is not an accurate statement. So as far as the defendant being a willing participant, the victim being a willing participant, we do only have Ashley Benefield's version of events for that night. That's all we have. And I know the defense in the motion or in the memorandum has mentioned that the court should take what she says as truth, that it's uncontroverted and unimpeached. But I have a case here, Judge, it's Early versus State, 223 Southern 3rd, 1023, which is a First District Court of Appeal case from 2017. And while this is talks about a jury, it does give guidance as to the type of situation that we have here. Even when there is no other witness to the events besides the defendant, a jury is not required to accept the defendant's testimony in support of his self-defense theory as true. Instead, it must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. So I believe that the court can wholeheartedly believe what Ashley Benefield said on the stand, or the court is allowed to disbelieve everything she said on the stand. And if that is the basis for this downward departure request, that he was a willing participant or an instigator, the entire evidence that we have of that comes from Ashley Benefield herself. And the state argues that her credibility is below, much below where it should be, and that it is obvious this was a pattern of behavior, that she had a goal to raise this child by herself and to get Doug Benefield out of their lives, and this was the culmination of that pattern. And so her credibility is lower than it should be. The other downward departure reasons that the defense mentioned, the one was the PTSD. But if the court looks at that downward departure reason, it says that that the defendant has a mental disability or problem that requires specialized treatment. And the defense has put on nothing to say that she needs specialized treatment for this, even if the court accepts that she does have PTSD. So the defense has not satisfied their burden for that. As far as isolated, the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. I would argue that does not apply. Obviously, this was not a one-time thing. This was a pattern of conduct over a very long period of time. Additionally, it's not unsophisticated. It's a culmination of a pattern. And if the court looks at the facts that came out in trial, that there were multiple firearms placed around the house, the daughter and mother were out of the house conveniently at the time when all of this happened, and this defendant is the only one still alive that has the correct, what she's trying to say is the correct version of events. So I would argue that that downward departure reason does not apply, or the defense has not met their burden. And Judge, I think it's very difficult when this entire trial has been about pretty much demonizing Doug Benefield and making this defendant the victim, when in fact it was the opposite. Doug Benefield did nothing but try to love this woman and try to love this child and try to do the best by them. And at every turn, she abused him, in my opinion. She tried to withhold this child. She tried to get him in trouble at every turn. She tried to do everything to undermine any relationship that they would have. And he continued to go back, which was probably his one fault, was that he continued to go back and he continued to think that he could make this work. And this defendant took advantage of that. And then when she can't get relief from anywhere else, shoots and kills him. And she got exactly what she wanted for a time. And for that, Judge, we would ask that you sentence her to the maximum 30 years.
Thank you. Rebuttal.
I'm good.
All right. Okay, so at this point, I've heard all the evidence. I've heard the arguments of counsel. Ms. Benefield, this is addressed to you. Please feel free to consult with your attorneys before you answer, or if you want to answer. But at this point, I always just check with the defendant and say, okay, I've heard, of course, there was a stack of letters that I got from your attorney as part of the downward departure. Heard Dr. Russell's testimony today, of course, presided over the entire trial. Heard the statements from the state as well. I always ask, though, is there anybody that I haven't heard from, any testimony I didn't hear, any evidence that I didn't hear, anything at all that I need to know to make a fair decision in this matter?
Your Honor, Ms. Benefield feels that I've spoken for her.
Excellent. All right. I also give a final statement, and I'm sure that you and your attorneys have talked about this at length. You are absolutely not required to make any statement. However, I also, whenever I have a trial case, we're doing sentencing, if it's an open plea, I do always give the defendant the last opportunity if there's any statements that you want to make. You're absolutely not required to. I'm sure you've already talked to your attorneys about it. But if there's any statement you want to make, please feel free to do so. If not, we'll just move on with sentencing.
I know the court will interpret her choosing not to as a lack of invitation and remorse.
Fair enough. And as I said, you're not required to at all. All right, is there any legal reason why sentence cannot be imposed?
No, sir.
All right, so the first thing we need to do is talk about the bases that have been argued for downward departure. And I think today it's an absolute tragedy that we're even here today. And I often, in these situations, sit back and wonder, how did we get here? How did life bring us to this point, not only here in court, but between the Benefields? I think both sides have acknowledged, because both the defense, Mr. Taylor, and the state talked about lenses and perspectives. And I think this is a good example of exactly that, where whatever lens you view this case from can really affect how you view the players, the results, the participants, and the outcome. So we've got the score sheet to start from. The issue is whether a downward departure has been sufficiently, the burden of proving that has been sufficiently met, and then whether the court would grant a downward departure. So the bases are, and I'm going to just take them in alphabetical order from the statute, 921.0026 subsection 2. The first one is D. The defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, or for a physical disability, and the defendant is amenable to treatment. In that particular one, there was the testimony by Dr. Russell that she has diagnosed the defendant with PTSD. It's a complex trauma. She explained the genesis of it and how she reached that conclusion. But importantly, what needs to flow from that is a description of what that specialized treatment is, what sort of treatment is important or would be necessary to treat that PTSD, inpatient, outpatient, what kind of mental health therapies, and so forth. So based upon the competent and substantial evidence that has been presented, I do not find that D has been proven by preponderance of the evidence, all the elements of D. F, the victim was an initiator, willing participant, aggressor, or provoker of the incident. The reason I asked that question, and I was looking around, is I had a case, and I thought I put it in my packet for today, but I'm not seeing it. There was actually a decision in the Florida Law Weekly within the past couple of months. It hasn't been too long ago, where that very issue was discussed. And the DCA in that case actually came down and said, when it talks about the incident, the evidence must support that the victim was an initiator, willing participant, aggressor, or provoker of the incident. And specifically said the court should not consider all of the pre-existing or attendant circumstances and just look at that incident. I think both sides took a great amount of time throughout this case to talk about incidents and events and happenings that occurred before September 27th of 2020. Do I have the date right? September 27th of 2020? But I think the case law talks about that particular day or that particular event. And it doesn't need to be, for this downward departure basis, the law is very clear. The defense doesn't have to prove it by clear and convincing evidence beyond a reasonable doubt. They don't have to prove or provide evidence that is beyond a reasonable doubt. The question is there competent and substantial evidence that in the incident itself, the victim was an initiator, willing participant, aggressor, or provoker of the incident? And quite frankly, the evidence, the preponderance of the evidence has established that Ms. Benefield's testimony is sufficient in and of itself. And I understand the state is arguing that to discount her credibility, but is there evidence in the record that proves by a preponderance that Doug Benefield was an initiator, willing participant, aggressor, or provoker of the incident? And there is. That was the entire basis of the self-defense argument. So I do find that the requirements of F have been met. G, the defendant acted under extreme duress or under the domination of another person. This is why I was asking about the case law, because I have not seen this particular statutory basis applied in this particular factual scenario where it's argued that the defendant acted under the extreme duress of the victim as a self-defense matter. But just because I haven't seen the case law doesn't mean that it doesn't exist and it can't be argued for that purpose. So for the purposes of today, using a similar analysis as I did under F, but also considering the past relationship between the parties, I think there has been competent, substantial evidence to establish by a preponderance that the defendant acted under extreme duress. The domination of another person, I just don't think fits. So to the extent that that particular downward departure basis requires that the duress comes from a conspirator, a co-conspirator, a confederate, or a principal, I could be wrong, but I think it applies, and I'm applying it here. Or I think it's been proven. And then J was the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. The case that I talked about a few minutes ago regarding victim was an initiator, willing participant, aggressor, or provoker of the incident, J has similar language. The offense was committed in an unsophisticated manner. So I understand the state's argument saying, hey, this was a whole series of events and was very sophisticated in its planning and execution. At the end of the day, the statute itself says the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. So if I look at just the incident itself, there's nothing sophisticated necessarily about self-defense and using self-defense. Isolated incident, the defense has pointed out, and the score sheet shows there are no prior acts of violence, there's no prior convictions. The case law requires, though, that all three elements of this be established. The final one is the defendant has shown remorse. Obviously, she's exercised a very, very fundamental constitutional right by not making a statement today. But I can also, I believe, consider the testimony that was provided during the trial. And remorse is not necessarily and doesn't have to be, I'm sorry I did this. Because someone is perfectly entitled to maintain their innocence even in light of a verdict of guilty by a jury. So I find that during the trial itself, that Ms. Benefield did demonstrate remorse for this entire incident happening and the culmination and the resulting death of Mr. Benefield. So I do find that J has been established. The non-statutory bases, there were none explicitly argued, but I'm going to make a ruling on the individual and culmination of errors for appellate purposes. Again, I'm not aware of any case law that establishes that. To the extent that there's an argument to be made that, and when I say individual errors, I'm talking about fundamental error, right? Because that could just be one thing and fundamentally vitiates the fairness of the entire trial. So individual or cumulative errors being the bases of a downward departure, I'm going to go ahead and make the finding that those are not, errors by the trial court are not bases for a downward departure, non-statutory bases. I may be wrong. We'll find out. The second part of the analysis is whether the court is going to exercise its discretion to depart. And that's where you really take into consideration those factors in determining, in light of all of the facts and evidence that have been presented, if this is a case that the court believes a downward departure should be granted. And as I said, I understand completely that two sides of this room are viewing this same case through very different lenses. As I consider all of the evidence that I talked about earlier that I reviewed in preparing for today, the jury's verdict, which they did not find Ms. Benefield guilty of the charged offense. It was a lesser included offense that did not include depraved mind. It included doing an act which resulted in the death of another person. I consider the score sheet and what Florida statute or chapter 921 discusses regarding the aim of sentencing, that being the primary purpose of sentencing is to punish, the secondary purpose is to rehabilitate. The PSI, which has been reviewed and considered, and I understand throughout the arguments that the defense has raised their disagreements. For what it's worth, the PSI in the factual part really just recreates or retypes the complaint affidavit. I don't really put a lot of weight on that. I don't need that because I presided over the entire trial. So I don't put a lot of weight on the factual recitation that was in the PSI. And as we all know, the PSI is not controlling on the court. The probation officer who does the report makes a recommendation, but unlike in juvenile court, where the Department of Juvenile Justice's recommendation is somewhat binding on the court, the DOC recommendation is not, but I did review that. And of course, as I said, I reviewed the defendant's sentencing memorandum, all of the various attachments, and listened to the statements that were made today from Dr. Russell, as well as David, Wes, Tommy, and Eva Benefield. And all I can say is thank you to everyone who took the time to write a letter and share your experiences. A number of them talked about growing up with Ms. Benefield, their interactions with her as they've grown up and growing into adulthood. Thank you for the statements regarding your relationships with Douglas Benefield and how his loss has impacted each of you. So when I look at the bases for the downward departure and I consider all of the facts and evidence that have been presented to me, my ultimate conclusion, Ms. Benefield, is that this is not a downward departure case. So with that said, the sentence of the court will be as follows. I'm going to sentence you to 20 years in Florida State Prison. That's to be followed by 10 years of probation. Upon your release, and the Florida State Prison was, of course, with all credit for time served. You must initially report to the Bradenton Department of Corrections. We'll be able to provide you a map of where that is. Cost of supervision will be a condition of supervision. Based upon the testimony of Dr. Russell today regarding you suffering from and being diagnosed with PTSD, the court is going to order as a condition of your probation that you obtain a mental health evaluation at your expense within 60 days of beginning your probation. You're to complete any recommended treatment, including residential treatment and aftercare if it's recommended, on the first attempt at your expense. You're to provide proof to your probation officer regarding the evaluation, participation in, and completion of that treatment. If it's necessary for your probation officer, you'll need to sign any waivers or releases that are necessary for them to get the information that they need or speak with your evaluators and treaters. I am going to order the forfeiture of the firearm in this matter, that being the Springfield 45. And I'm ordering that you have given up all rights, title, and interest to the same. I haven't heard anything about restitution at this point. I am going to order restitution. I'll reserve jurisdiction to determine the amount of restitution, the payee or payees, the payment schedule, if any, and other terms and conditions of restitution. I'm also going to reserve jurisdiction on the restitution to determine whether or not to waive or reduce the monthly cost of supervision and or the fees and surcharges that are associated. I'm going to impose the following monetary obligations: the felony adjudication of guilt court costs, $100 cost of prosecution.
200.
Do you have an affidavit?
I don't have it with me.
I can look.
If you need one, we can get one.
It's required by Florida law.
Just, there's,
If you want to
3,000
continue on,
pages.
we'll try and find it.
All right. If an affidavit is for cost of investigation is presented, I'll order $200 to the Marietta County Sheriff's Office. For now, I'm going to make all the legal financial obligations a condition of probation. All right, State, now that you've seen where I'm at with the sentencing, was there anything that you want to do, any further arguments, anything else you want me to consider?
Judge, my only concern would be the mental health evaluation. I would prefer that it not be with Barbara Russell when she's on probation and has to do the mental evaluation.
You don't want what?
You have ordered that the defendant do a mental health evaluation when she gets out on
Correct.
probation, and I would have requested it be someone other than any of the doctors that were involved in this case. So not Barbara Russell or Dr. Quintal or Dr. Broder. Those-
Okay. I'm not going to order that. I'll let you pick your mental health professional that you want to see and consult with. Sir, now that I've told you where I'm at, was there anything that I need to explain or clarify?
No, sir. If you would, how long is the period of probation?
It was 10 years. Okay, Ms. Benefield, you have 30 days to appeal the judgment and sentence of, oh, yes, sir.
Make one statement for the record. I object to the record and argue it's an abuse of discretion based on the undisputed facts, not to grant a downward departure.
Oh, yes, sir, absolutely. I think that's generally preserved no matter what, but
I do too, but
I print your belt.
the appellate courts like to find non-preservation, so I'm overly careful.
I understood. Belt and suspenders, no problem at all. Yes, sir. So objection to the abuse of discretion for not granting the downward departure. Noted. All right, Ms. Benefield, you have 30 days to appeal the judgment and sentence of the court. If you can't afford to hire a lawyer, one will be appointed to represent you. Oh, go ahead.
Sorry, I just have one thing
Is it regarding appeal?
regarding,
Appeal?
no.
Oh, well, go ahead then.
I was going to ask the court if the court would make arrangements to ensure that Ms. Benefield remains in Manatee County for at least 14 days, if not 30, so that we can tie up all the loose ends in preparation for the appeal.
Okay. I don't know how much pull I have over that. DOC comes gets people when they come get them.
Can I suggest that Your Honor set this for a report in perhaps 30 days?
All right, why don't you send me an order directing the sheriff to hold her pending any final hearings or matters? And I'll,
Judge, the most specific thing, we're going to be filing this motion for bond pending appeal, so that's why.
oh, keep her there for that.
Yes, so to avoid the necessity of her going back and forth.
Absolutely. So do me a favor, contact Kelly, my JA, get that set. I didn't see it's been filed yet, but get it filed.
It has not, but I will file it tomorrow.
All right, get it filed. Talk with Kelly about getting a hearing date, and then I'll sign an order to hold her until after that date. Absolutely.
Thank you, Judge.
Thanks.
Of course. Okay, for the appellate purposes, what I was going to say is, ma'am, speak with your attorney. You could hire someone if you want, a private attorney for that. If ultimately you are going to seek the services of the public defender, I'll just need a financial affidavit and a motion to appoint. And then once Mr. Taylor completes all of his obligations as trial counsel, we'll get a local PD appointed and then the 10th Circuit PD. All right, ma'am. Thank you very much.